And if I had to be another person to stand up, if I think after really going through this and looking at the files and looking at the case, if I really feel that Karen Reed didn't do this and I have to be a voice that stands up and helps, I will.
You're expected to learn more about the allegations against the girlfriend of a Boston police officer who was found unresponsive in the snow Saturday morning. I-Team sources say Karen Reed was in a relationship with John O'Keefe. She's facing charges including motor vehicle homicide and manslaughter.
We're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Now, just be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in his blood. I was the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
I'm going to tell you one thing. Karen Reed's not going to fold. Karen Reed's not going to give up. Defense team's not going to quit. The Free Karen Reed movement is going to continue. We will continue to raise funds for her. We will continue to do standouts across Massachusetts, across the nation, across the world to let everybody know what's going on here in the state of Massachusetts, the corruption. And we will continue to get the word out there. Believe me. Believe me. Good snowy Sunday morning. If you live here in the Massachusetts area, we are experiencing a little bit of winter weather today. A lot more hype than I thought it was going to be. I went out, it was kind of felt like it was a nothing burger to me, but we're here hanging out on this Sunday morning wake-up show, and I'm glad to be here with all of you. And what my agenda for today is I wanted to go through the complete Karen Reed motion hearing that was the other day, a couple days ago. I had Nan Gallagher on, wonderful attorney, on the other night, and we planned to go through it, but there was just so much great dialogue back and forth. We didn't completely get through the motion hearing. So I want to review and react to that today. I really looking forward to having Nan back on the show sometime soon, because she's been a valuable asset to breaking down a lot of this conversation that goes on in the courtroom and the back and forth, which is very nice to have an attorney's take on all of that. So I really appreciate Nan jumping on the last 2 times here and helping out on LTL Media, helping me out. Nice to see everybody this morning. Still got a little nasal congestion. I actually left work sick yesterday. I wasn't feeling well. I went home and rested, and then I came here to the studio and worked a little bit here. And I actually reconfigured this room yesterday. I'm actually really happy with it. I just wish it was a tad bigger so I could get my camera angles down, but I think it's looking pretty good. I posted a video of that yesterday, and I can actually give you a little bit of a preview here. I have a couple cameras set up right now, and just kind of give you guys an eye view of what I see in front of me. So let me go to camera 2 here. This is a great spot when a guest comes in. Obviously, we'll pull the chair a little bit forward, but I've now switched out to 2 chairs that are in front of me instead of this table that I was using before. And that's basically what it looks like. That's my camera in front of me, and that's the camera that you're seeing. But wonderful spot here. We can change the background. We can put a fireplace, a fish tank. If we're playing a video, we can pop a video up on the screen, and it's a really nice spot. And now we have 2 chairs, which I feel a little bit more better to set up camera angles and get more of that interview style when people come in. So thoroughly impressed. It's looking really good. I just wish this room was a tad bit bigger, but we'll work through it and get through it. And I still think it's great. I still think it's great. Still have some nasal congestion. Yeah, I don't drink. So I know everybody keeps saying this hot toddy thing. I don't drink a sip of alcohol. So, and I think that's what a hot toddy is. I think it's alcohol, right? Is that alcohol? Let's look. Yeah, I don't drink. So not going to drink, not going to have any alcohol. Sorry, but I appreciate it. So listen, what's going on today? We're going to get through this motion hearing. I want to replay through that, review and react to it. And then also the big buzz tonight is Ted Daniel from Boston 25 is going to have an interview with Karen Reed, her first sit down in probably, wow, when was the first sit down? 3 years ago. So maybe, 2.5 years ago. And we're going to hear a little bit more of an account of, he's going to ask her the tough questions. He said that she hasn't backed down. She answered all of his questions. Not sure how long the segment's going to be. I'm going to probably guess 15 or 20 minutes. So I wouldn't guess that we're going to get this hour episode, but I would be really impressed if we did, or even a half an hour. So I'd probably say 15, 20 minutes. We may hear that interview. So I'm going to do my best to try to stream it tonight. I'm just unsure of when it's going to happen. We know the Super Bowl is tonight. That's probably going to end around 10 or 10:30. And then I didn't even know this. Rob Lowe has a show called The Floor. And that I looked airs for about 43 minutes with commercials. So I don't know. Maybe 11 o'clock, 11:30. That's probably, I'm guessing, when this interview is going to air. But I don't know. I'll keep my eye on it, see if I can lock down a time. And if we can lock something down and get back up here to the studio, I'll definitely live stream it and see what goes from there. But anyway, let's get to this motion hearing. I want to go through this, review and react to it. And just some notes. Obviously, we're going to hear, and I talked about this with Nan on the show the other day, possibly some Brady violations going on, I would say. We know that Jackson is going to submit a very lengthy motion to dismiss that we're going to hear in the next, I think their deadline for that is on the 11th. He asked for a little bit more time. I think Bev was pretty dead set on the 11th, getting that in an 11th, which is very interesting because what is going to happen on February 10th? February 10th, we have the second part of the Trooper Proctor trial or disciplinary hearing. And I'm going to pretty much say and go out on a limb here, and I could be wrong. I could be wrong in all of this, but I think they're going to listen to the second hearing, say, all right, we have all the evidence. We're going to take all this into consideration, and they're going to bury this thing until after the trial. That's just my own opinion on it. I would be shocked if we heard something on the 10th that, at 5 o'clock at night, or the 6 o'clock news spot that Trooper Proctor's been fired. I would be shocked because I think they're going to kind of bury this thing and drag it out. Obviously, we're going to hear in this hearing, Hank kind of throws Lally under the bus about this sallyport video. And we're hearing more about the infamous reversible upside down left right sallyport video. And we've now found out that it is on a retired sergeant's iCloud account. Little sketchy. It was stored there in some iCloud account from a retired sergeant. That's a little sketchy. And obviously, we're going to hear more about Brian Higgins' phone call at 1:30 a.m. And there is video of that. So, okay, let's get into this. Let's play through it. Full walkthrough of the Karen Reed motion hearing from the other day. And I will boost the sound.
To save me time, does your expert in his affidavit say that this information was erased or that it wasn't there?
It wasn't there.
Okay.
It was erased by an operation of automation.
But do I bother
Harry,
reading your
a little
expert's affidavit again so it's not in there?
And I'll address what
All right.
our concerns are in my oral statement.
All right. I'll hear
The
you.
court, may I?
Yes.
The court started by asking what is.
And by the way, I just want to point and make everybody aware. At the top of the chat is Karen Reed's defense fund link. If you feel and you can, please donate. Click on that link, donate. Put something in there about LTL Media. It'd be great. And I'll look at the end of the show. Maybe we can get a rough total if any donations came through that. And I thought it was fucking awesome the other day that everybody stood up. And there was a huge $3,000 donation the other day that everybody stood up and raised money for Karen and got back just about that $12,000 that was wasted by the Commonwealth. Phenomenal. Just phenomenal. Everybody's just really phenomenal. All right, let's hear Jackson.
What is it that the defense is asking for? Basically, we're asking to be
I
treated
agree, Scott.
equitably and fairly. This really is an issue of equity and an issue of fairness.
I mean, you look at, and I'm going to pause this again really quick, and I just want to comment on Scott's comment here. You know, you look at the Alec Baldwin case, Brady violations all over the place, and a very reputable judge in that case dismissed it. Now, do I think that if Baldwin would have went to trial and there wasn't all these mishaps by the police department, could he have been convicted? Yeah, I think there was some responsibility there. I think there was some responsibility. His name was basically signed on everything there. He had full control of everything that was going on there. So that was on his hands. But because of shady and faulty police work, tons of Brady violations, and it gets dismissed. It gets dismissed. All right, let's go back to Jackson. Nice to see him back in action.
And the court maintains
Good morning.
This court maintains the inherent authority
Getting there.
to issue sanctions when there is an injustice. And those sanctions can include something like cost-shifting sanctions. And there's a body of law that exists that deals with this exact thing. And that body of law includes the case of the Committee for Public Counsel Services versus the Attorney General. That's at 480 Mass 700. It's a 2018 case. The court may remember what was, I think, pretty widely known here in these parts, which was the Amber scandal. Had a bunch of cases going back from 2010 all the way through.
I'm very familiar with the case.
All the way through 2018, and it culminated with Justice Gaziano discussing in his opinion, single justice opinion, exactly these types of things. And what Justice Gaziano said was, quote, the Attorney General does not dispute that the court has the authority pursuant to Rule 14, sub C, sub 1, to impose remedial monetary sanctions for a discovery violation. And he cites...
real quick, and I just want to kind of point this out. There's been a lot of active chatter on Twitter with our Attorney General, Andrew Campbell, and Maura Healey now is coming out. Since Trump has been in office, they've been talking a lot about suing Doge and worried about, you know, the migrant crisis here in Massachusetts. And I have constantly been tweeting at both of them to get us answers about what happened to Trooper Enrique Delgado Garcia. And that seems to be constantly ignored. And, you know, I'm just going to look at my counter now. We're at 149 days. 149 days until that man lost his life. And there is no answer. And I reached out to the family just the other day to check in. Hey, how are you? How is everything? Have you gotten any updates? No updates. No updates. Still investigating. Investigating what? Investigating what? You know, let's round it up. 150 days to get a report? To investigate? I mean, you have video of the incident. Let us know what happened. And Maura Healey now is announcing that she's going to run in 2026. This is why it's so important for all of you here in the state of Massachusetts. If you are disgusted with the people that are running these departments and the heads of our government here in Massachusetts, and believe me, there is a lot of corruption. There is a lot of corruption. But the best thing that you can do is vote against these people and get them out. It is time to clean up this state. We are not getting the truth. We are not getting the truth, people. These people in power don't give a shit about anything. They don't care about you. They don't care about our communities. All they care about is their political status and the money that is flowing through their pocket, and keeping people and trying to put people away like Karen Reed for something that she did not do. That is their motive here in Massachusetts. People, you need to get out and vote. Please get out and vote against these people and get these motherfuckers out of office. They don't belong here. They don't care about you, and they don't care about me, and they don't care about this state. All right, let's go.
Commonwealth v. Firth, indicating that sanctions may be imposed under Rule 14 for failure to comply with discovery obligations, and sanctions should be tailored appropriately to cure any injustice resulting from a party's non-compliance with its discovery obligations. So the real question before the court today is and really the only question before the court today is, has Ms. Reed suffered any prejudice based on blatant discovery and Brady violations by the Commonwealth? And the answer to that question is a resounding yes, she has. Your Honor, Ms. Reed, as the court knows, is on trial for her life, and she's been expending precious resources for some 3 years now defending herself against provably false allegations. And at the center of that storm of defense are these sallyport videos. It should be pretty straightforward.
Yeah, you're going to hear about Jackson's going to pop up here and say, we just still getting bits and pieces. And then that shocking information that we're going to hear about a retired sergeant on the iCloud account was storing videos. You know, just random iCloud accounts, key pivotal evidence in a case, in a criminal case. Yeah, we'll just let John Q. Public now hold on to that video. Pretty shocking. Pretty friggin' shocking. All right, let's go.
I mean, it's just a series of videos at a particular location for a particular time. And that time is January 29th, 2022, from midnight until 11:59.
Blair checking in.
24-hour period, 23 hours and 59 minutes. Should be pretty simple, but
You're
it
saying
has been anything
was good.
but simple.
I don't know if you're still
In this
here, but
case,
what was
we've been
good?
asking for a full download of every single one of those cameras and all that footage from January 29th, 2022, from 12 a.m. to 11:59, but we've never gotten it.
When did you first seek it?
Thank you for donating.
We asked for the preservation
Karen
on
Reed
February
has been
2nd, 2022, when Mr. Yannetti said retain and maintain all physical evidence. We've been seeking.
And that order did happen. Saw it posted on X. I've seen it posted in the Justice group. So, but Bev saying, oh, well, you know, I don't see it. Yeah, it was posted. It was there just days after Karen Reed being arrested and acquiring Yannetti as an attorney.
Before the first trial. We didn't get them before the first trial.
Do you have a date? Do you have any chronology?
Hello,
I
Colorado.
can certainly provide those, but it's been.
I'd like that. I mean, that would be.
I'll be happy to do that. It's in discovery request after discovery request after discovery request. Basically, there's also a catch-all. We've been asking for all physical evidence concerning video footage from Canton PD from well before the trial. We didn't specify which cameras because we didn't know which cameras had video footage. We didn't know how many cameras there were.
Really?
But we didn't get anything from the Commonwealth. And I'll address that in particular in just a second. Mr. Lally didn't give it to us before a full download, before the trial. The Commonwealth didn't provide it during trial. And today, as I stand here,
Now
we
they're
still
getting
don't
more
have it.
Right.
And interestingly, Mr. Brennan does make mention in his opposition that, quote, at no time has the defense ever made a formal preservation request. I found that interesting for two reasons.
They did.
And I have two comments about that. First, as the court record reflects, on February 2nd, 2022, I just referred to it, Mr. Yannetti filed a preservation demand for, quote, all physical evidence to be maintained. That DVR, the footage on the DVR.
Now, what the argument is going to be that they didn't say video. All physical evidence, doesn't matter if it's a cough drop, a tissue, a Gatorade bottle, all physical evidence.
Is physical evidence that was required, not requested, but required to be
Right.
maintained by the Commonwealth pursuant to that demand. But second, and this is probably more important, it wouldn't have mattered if we didn't ask for it to be maintained. It wouldn't have mattered if we didn't ask for it to be preserved. This was a self-executing duty by the Commonwealth. As Justice Gaziano stated in the same case, the Committee for Public Counsel, quote, "A prosecutor's core duty is to administer justice fairly. To fulfill that duty, a prosecutor is required to turn over exculpatory evidence to a defendant without regard to its impact on the case. The failure to disclose evidence favorable to an accused that is material either to guilt or to punishment is a violation of due process. Litigation strategy plays no role in this process."
Yeah. And how many times that Karen Reed's rights have been violated during these hearings, during these discovering hearings, these motion hearings? How about at trial? How about at trial? How many times do you think, let me know in the chat, that Karen Reed's rights have been violated during this whole process, this last 3 years? It's mountainous.
Under our rules of professional conduct, a prosecutor is required to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate guilt of the accused or mitigate the offense. And he cites Massachusetts Rule of Professional Conduct 3.8 subsection D. The Commonwealth's Brady obligation is self-executing, Your Honor. It wouldn't have mattered one whit if we didn't ask for that footage, but it turns out that, in fact, Mr. Yannetti did ask that it be maintained. And the Commonwealth has still failed to preserve it. What we have gotten, it appears, are scraps and fragments of videos that the Commonwealth has decided on their own, and within their own time frame to dole out to us over the course.
And who did scraps and pieces of their data? Who's the one that extracted only the data on their phone that they wanted to turn over to the Canton PD? Did it on his own. Not like, hey, I have nothing to do with what went on in this investigation. I have nothing to do with what went on in 34 Fairview. Here's my phone. Sure, take a full extraction of it. No, I'm going to go in, use an FBI facility, and only give you certain bits and pieces of information that I want to hand over. Unreal.
Course of months and years. And included in that
Exactly.
scrap and fragment was a video that was missing 42 minutes. The court is well aware of this video. It was heavily litigated and heavily referenced at the first trial. That's the exact time frame. The missing portion is the exact time frame that the SUV was being pulled into the salary.
And tossed the phone.
We got that video on April
Military
4th,
base.
just days before the first trial. Keep in mind, it's a video from January 29th, 2022. Another one of those videos was the inverted video that has now seen some fame.
Yeah, I'd say.
That the Commonwealth tried to sell to the jury as a true and correct copy of a video within the sallyport, and we got that one after the trial started, in the middle of trial. So why were we getting videos from January 29th, 2022, 2.5 years later? And why were some of those videos altered or manipulated and not in their proper format? We still don't have answers to those questions.
A little scary.
And literally, while we're asking that question and while we're pondering that question, a couple of days ago, we're getting yet more videos, scraps, piecemeal. We got another sallyport video just a few days ago, this one showing the Lexus backing into the sallyport from some exterior camera. And that also is exculpatory evidence. Mr. Brennan writes in his opposition that the idea that the defense has been misled or was misled in its efforts to try to go secure that DVR footage is a distortion of the facts with, quote, no legal merit. Really? A distortion of the facts with no legal merit? Where's all this footage coming from, if not the DVR?
Yeah.
The only place it was held. It's the only place it was captured.
Who's got it?
So of course we were misled.
Multiple copies of it out there with all the police friends in Canton, right? Here it is, everybody. Making the rounds. Making the rounds.
By continually getting these piecemeal snippets of footage from the DVR, from the very source, had to have come from there, coupled with the Commonwealth saying, and Mr. Brandon saying, yeah, come on out. You can have your expert come out.
Love this comment. Thomas T says, I always destroy my phone on military bases. Doesn't everyone? Oh, yeah, of course. Let's take a ride down there. I like when Turtle Boy went down to that actual base and stopped at the little entrance kiosk there and said, hey, I want to destroy my phone. Is it okay to go through, in here and went through the whole process? That video was awesome. And the guy's like, I have no idea what you're talking about. And he said, well, he explained the situation. It was a guy, there's a military pass, came down here and destroyed his phone. Can I do that? It was fantastic. It was great. Really, really good stuff. The guy's like, you need to go up and just turn around and go away. Why did they stop him and shake him down?
We'll provide the DVR. You can have him look at it. He can bring his equipment, download whatever you want from that 24-hour period. So what were we to believe? That it was on the DVR. It had to be.
Excuse me.
How else were we getting these piecemeal videos?
It's scary.
And they've had that DVR for 3 years. They knew exactly what was and what was not on that DVR. They had to have. This has been the center of a storm that surrounded this case from the jump. And to claim otherwise, it's just patently absurd. So Mr. Brennan also wrote in his opposition that Mr. Jackson said, don't touch the DVR, don't mess with it. So I informed Chief Rafferty, tell your staff, don't touch it, don't mess with it, almost intimating that it's my fault that we didn't know what was on the DVR. That's absurd also. How am I supposed to know what is or isn't on the Commonwealth's DVR?
Yeah.
What I actually said, that was a sort of a liberal interpretation of the facts. What I actually said was, Mr. Brennan, do me a favor, if we're going to come out there, just don't have anybody download it in advance. Let's do it all together when we're all in the same place. That's what I said, and he accommodated that. He said, sure, we'll agree to that. So based on this history of getting these small clips from January 29th, we knew there had to be more footage. So when Mr. Brennan came on board, we made the request to him as well as the requests that we had made to his predecessors. We want all the footage for that 24-hour period. And lo and behold, we started getting more clips, more snippets, more piecemeal bits and bytes
Scary.
From that DVR. And one of them was a clip of Brian Higgins standing out in front of Canton Police Department in the parking lot in the freezing cold at 1:35 in the morning on January 29th on his cell phone.
Yeah, and who the hell is he talking to? Who do you think he's talking to? Let me know in the chat. I know I have a feeling I have my opinion of who he's talking to. Who do you think he was talking to? Let me know in the chat. I think it's one or two people. But I have mine. I have my prediction who he's talking to. Yeah. I see the names. He's calling Domino's. That's right. He's ordering pizza. The pizza guy. 1:30 in the morning. There's fucking no pizza place open in Massachusetts at 1:30 in the morning. Sorry there, Plevin. You're wrong. You wrong. I always thought it was Brian Albert. I thought it was Brian Albert. Yeah. Some say Proctor, some say Berkey. I haven't seen Jennifer McCabe, but I always thought it was Brian Albert. Lisa, thank you for becoming a new member and supporting the channel. I appreciate it. You wrong. All right, let's go.
To punctuate the importance of that
Definitely
video
not the
footage,
pizza guy,
recall
right?
that this issue was raised at trial. We talked extensively. When I say we, both the Commonwealth and the defense, me in particular, spoke with Mr. Higgins about this issue. It was raised at trial, and Brian Higgins never once, not once, on direct examination or on cross-examination, admitted to having made a phone call in the middle of the night on January 29th.
Ooh, I want to go back and find that. We got to go back and find that. I won't have time to do it right now, but I want to go back and find that when they questioned him about that. It was very interesting. Now look at, there's more things coming out now. Did you make a call at 1:30 in the morning? Nope. Oh, guess what? Here's the video. Here's the video. Here's some things that I would like the defense, and it was funny. Nan and I talked about this the other day. Here's some things that I would like the defense to focus on this time, and I hope they have an expert or they attack the Commonwealth, the police department that collected this evidence. You know, and I just said this the other day is kind of a parallel conversation, and I think that Nan and I are going to do something like this. But so you look at the O.J. Simpson trial, and there's recently been a 4-part series that has come up on Netflix. If you haven't seen it, you have to watch it. It's brilliant. And you're seeing literally a lot of evidence that was collected in witnesses that were talked to, but they were never brought into trial by the Commonwealth. That literally, and I'm not saying this for Karen, but just saying that literally was sunk O.J. Simpson in like 5 minutes. It's crazy. But my point in all this is what I'm getting to is there was thousands and thousands and thousands of hours of footage that was shot as they were collecting this evidence. And what I would like to see the defense focus on this time around, and I think it would be more of a pivotal point, was how the evidence was collected. I don't think they did that enough in front of the jury or enough during the first trial. I would say things like, hey, when you collected this, look at, you have a Solo cup and it's contaminated and that is not a proper storage. And when you collected it, you weren't wearing rubber gloves. I would get more into that. I think that would hit more with the jury this time around. I would like to see that. And I'd like to see, and I know a lot of people on their shows have talked about a policy and procedure expert to come in. Maybe they go through and get the Canton and Mass State Police policy and procedure, show it up on the screen. Here, this is what you're saying, how you're supposed to process a crime scene. But clearly from all of these videos, with a fucking snowblower, you're blowing around a crime scene everywhere. How is that proper? Where does that say that in any of your policies? And I think it would be a huge point to touch on all of that. But anyway, before we get back to the video, if you haven't seen that 4-part OG series on Netflix, watch it. It will completely blow your mind. The guy totally did it. And there was a lot of missteps in that trial. All right, let's go.
And yet now, after the trial, we get a video of him doing exactly that. And that also proves that he lied in front of a federal jury. In front of a federal grand jury when he testified that he didn't have or make any phone calls in the middle of the night. That is called exculpatory evidence.
Sure is.
Brady evidence, and it was withheld in its entirety during the first trial and for the last 3 years. And it's against that. The reason I bring that up, Your Honor, it's against that backdrop that we then say to Mr. Brennan, kindly give us the footage. I don't want this piecemeal thing to keep going on. Just give us the raw footage. We'll send an expert. So the plan was put in place, and experts were retained, and flights were booked, and hotels were reserved, and transportation was arranged, and all at Ms. Reed's expense. She's writing the check for all of this. And our expert flies out to Canton, walks into the room, and within 10 minutes, they open up the front plate of the DVR, and lo and behold, Commonwealth says and agrees,
Erased.
Oh goodness, there is no footage. It was overwritten within 30 days. What? How could that possibly be? So the expert calls me Mr. Jackson, what do you want to do? And I said, I don't know. I'm not a tech. That's your job. I don't know what to do. If it's overwritten within 30 days, I don't know. Maybe there's a log. Let's find out who has access, whose digital fingerprints were on that DVR, who downloaded the footage, when it was downloaded. What about these clips that we have? I'm very confused. So the expert goes back and says to the technician for the Commonwealth, Colleen Crawford, well, let's at least download the log. At least we can have access to that and we can start unraveling what's going on here.
Gone.
Oh, sorry, that's been overwritten.
Gone.
There is no log. You get no footage. You get no log. This was a complete and utter waste of time. According to the Commonwealth, that system, as I said, overwrites every 30 days. So by February 28th, I counted them. By February 28th, 2022, every single frame of that footage should be gone. So how did we get the inverted video in April of 2024? How did we get the video clips of Brian Higgins in October of 2024? How is that possible? The only explanation, Your Honor, is that the Commonwealth downloaded the entire system within the first 30 days. Otherwise, it's gone, admittedly. And all of that has been withheld from us for 3 years. Then to add salt to that wound, the Commonwealth allows us to go on this wild goose chase, spend $12,000 some odd dollars of Ms. Reed's money, and fly an expert out to Canton for
Which was recovered by the power of the people. And fantastic job on all of you.
absolutely no reason. Zero. The 30-day overwrite protocol is something that their technician absolutely would have and should have and did know before we ever set foot.
Lumpy, thanks for the one gifted.
She was well aware
And
of
again,
exactly
thank you
why
for
we
the
were
one
going
gifted.
out there. We were going out there to download footage from 3 years earlier. She knew it. We knew it. Mr. Brennan knew it. Everybody knew it. But within 10 minutes of walking in the door, it was revealed that there, in fact, was no footage. And that's a fact that the Commonwealth had to have been aware of for the last 3 years. Yet Karen Reed is the one having to foot the bill for what turned out to be just a snipe hunt.
It's true.
It's not fair, and the Commonwealth should reimburse her for this fool's errand that was not of our making, of her making. The Commonwealth has since told us, Mr. Brennan told us, that remarkably he went to Canton PD, and this is in his opposition paperwork in his declaration, and he spoke with some officer. And that officer told him,
So you mean John Q. Public, right, Kim? John Q. Public now. Not a cop anymore, just a random retired citizen. It's scary. Stick it on the iCloud account. What has happened to that video? I think they need to pull him in and ask him some questions.
that he, the officer, personally made a copy of the entire January 29th video footage and placed that copy in some sort of an iCloud account.
Jesus Christ.
Not on the DVR system, not in the official data bank in which it's supposed to be stored, but on some iCloud account. And we're finding out about this in 2025. It's outrageous. What it is this entire situation surrounding this DVR and the Commonwealth's maintenance of that DVR and the footage on it is a complete dumpster fire. And Ms. Reed has to pay for the fire extinguisher. And that's not fair. The High Court and the Committee for Public Counsel, the same case that I
Yeah, really, Lisa, where are they?
will know this because this was sort of the big takeaway from that case is Justice Gaziano fashioned a cost-shifting remedy against the Commonwealth and for the defense. And that included the entire cost of investigating and locating and contacting nearly, I think it was 10,000 defendants. It was an enormous amount of money and an enormous undertaking. And the Commonwealth had to foot that entire bill. And the reason they had to foot the entire bill is because the Supreme Court decided that it was prosecutorial discovery violations and cost-shifting remedies were in order. We're asking absolutely no more than that from this court. Fairness dictates that Ms. Reed be reimbursed. And I'll submit, Your Honor.
You know, real quick, if this judge had any moral compass, and didn't have her fangs and claws on dead set of convicting Karen Reed, she would dismiss this. An honorable judge would dismiss this by now. Multiple Brady violations. And that's scary. To see now, 3 years later, evidence that was held back, that's really scary. If you all can do me a favor before we hit play here and we hear Hank Brennan, just smash that like button below. We only have about 165 likes, and there's well over 400 people in here watching. So it's free to do that. If you can smash that like button for me, it helps get this stream out in the algorithm and get some more people over here to start hearing the truth. And also, if you'd like to donate to Karen Reed's Defense Fund, the link is pinned to the top of the chat. Click on that, make a donation. Put something in there about LTL Media. I'd like to maybe do a rough total at the end of the show and see if we got a little bit of money in the piggy bank for Karen. All right, here we go. Hank Brennan. Oh, no. It's going to poorly bird.
Mr. Brennan?
Pee Wee Herman.
It's notable that the defense purposely conflates.
No good morning. No may I. May I please the court? Nothing. Good morning, Judge Cano. Good morning, court. Nothing. Jumps right into it. Rude. No manners.
It's two very separate issues. If you had a chance to read their motion, they suggested they should receive costs because they hired an expert, came to Canton, and didn't receive the information they wanted. Yet today in the argument, they try to give you a historical complaint about the production of videos in this case. That is a separate issue. That's a Rule 14 issue, but that is not the motion before the court. The reason I suggest they conflate the issues is because they know their merit for costs. I mean, their motion for costs has no merit whatsoever.
You're back.
So what they're trying to do is incite facts, invoke this injustice they've created so that the court looks at the motion that they actually filed and gets it distorted. It is disappointing to stand before a court and file an affidavit as an attorney and have someone else have a cross affidavit. Frankly, in my career, when that has happened on rare occasions, I find that embarrassing. There is very skilled and able attorneys in this courtroom, and to work out discovery matters and agreements is something that attorneys always should do. And that is what I've tried to do in this case. I have tried to give the defense the best opportunity I can to get whatever information they want, whether it is required or not required. Yet, I'm standing here today, and I have to now share with you my conversations with the defense. I have to share with the court my position, which is contrary to the defense, because they have lodged a motion asking for money that they are not entitled to. If I stand back and do nothing and remain the dignity of the court, then what happens is there are claims that just float out in nowhere, and a lie unchecked becomes the truth. So now I must stand before you, and I must tell you what happened.
Christine, thank you for being a member for 12
When
months.
I entered this case in September and I began to look at discovery, I saw a video produced in August from the Canton Police Department, and we immediately turned it over to the defense. I began a study of the case and tried to articulate and account for all evidence and make sure the defense obtained everything that they were entitled to and more. The defense asked me to try to account for the video because they believed it had been an issue in this case. I looked through the docket. There was no motion to preserve videotape. I read the pleadings. Attorney Yannetti was meticulous in his motion.
It said preserve all physical evidence, sir. It said preserve all physical evidence. That's a pretty wide scale of what they're looking for. But now he's going to say, oh, well, he didn't say video. Preserve all physical evidence. Should cover it all.
Motions to preserve. It was admirable. It was meticulous.
Now
the
he's
work he did.
insulting He's insulting Mr. Yannetti right now. Patrick, thank you so much for the 10 on Cash App. I appreciate that. Lumpy is a member of 4 months. Says, thank you, Brian. Ghost Crew and mods, chill chat. Thank you. Appreciate that. We have a great chat. Let's go.
Motion to preserve, and that has some import. It doesn't relieve the government of their obligation to provide Rule 14 discovery or exculpatory evidence or Brady evidence. It doesn't relieve the Commonwealth of their obligations to be dutiful, but it is difference in kind, because the defense, if they want something
Yes.
that is not obvious,
Right,
they
Kim.
put the Commonwealth on notice. Having practiced for almost 3 decades, you file motions to preserve within 24 hours, 48 hours, or 30 days. And so when Mr. Jackson called me, Attorney Jackson called me, and he said he wanted to come
right
out
there.
and bring an expert to look at the NVR or DVR of the Canton Police Department, I had never seen that in 30 years. It's not part of our obligations. He's not entitled to come into the Canton Police Department with his own experts and download his request. But
with all the shady shit that has happened in this case, I'd say, yeah. Right? Would you, at this point, say, let's say there's another piece of video that just shows up, something they find. Would you feel confident enough as Karen Reed and Karen Reed's defense team say, Commonwealth, go ahead, collect it, send us over a copy? Would you feel confident about that? No. I'd want my expert there. Just like when they pulled the telematics system from Karen Reed's SUV, they had one of their experts there to oversee it, to make sure that it was preserved and taken out correctly, to get that data from it. So, yeah, I'd probably want one of my experts there.
in the spirit of transparency, in an effort to help the defense so there will be a fair trial and they can obtain all the discovery, understanding the history of this case, seeing that there was an August videotape post-trial, I wanted to do what I could to accommodate them. So without any hesitation, despite
Hank, you're just saving the day.
Motion to preserve, I invited him to come to the Canton Police Department. I called the chief of police. I asked the chief of police, although this was unique and novel, unprecedented, could the defense come and access their material? Typically, the Commonwealth will download it and provide them a copy. She had no hesitation. And so I called Attorney Jackson back and I said that we would allow it. Attorney Jackson expressed concern, understandably, being a defense attorney, that almost 3 years later, the video may not be on the NVR. I had the same concern. I want all of the evidence. I'm not looking for evidence that's good for the Commonwealth or helpful for my case. I want all of the evidence. And so after he expressed the concern, I made clear I had no idea what, if anything, was on the NVR.
Periodically humble. Thank you for becoming a new YouTube member.
Jackson didn't
Appreciate
want
that.
He wanted his expert to be the person to open the NVR. And respecting his position, providing a professional courtesy, I agreed. Didn't mislead him. I didn't think there would be video. I had no idea. So Mr. Jackson, Attorney Jackson, pardon me, sent out his expert. And by the way, the expert that came was not
very, very condescending through all of this. Didn't greet the court, didn't greet the judge, insulting David Yannetti, insulting Alan Jackson. Let's go.
the expert they designated. I got a call because we were in court on a hearing that they had sent a different expert they hadn't noticed. And my response was, it doesn't matter. Whoever they send, let them look at it. And so when they did, not surprisingly, the information had been overwritten.
Excuse me.
While there was a 30-day override on that machine, I believe the defense expert knows that there was a backup hard drive which kept materials longer than that 30.
Let's get to this. Peggy, wow. Thank you so much. So much. Karen Reed is factually innocent. A $300 super chat. I super appreciate that. You know what I'm going to do, Peggy? I'm going to take $100 of that at the end of the stream, and I'm going to donate it towards Karen Reed's defense fund. So we'll make that happen today. Thank you so much. I appreciate that. Super, super nice of you. Thank you. And you have been supporting this channel and these streams for quite a long time. And I really do appreciate you. Thank you so, so much. And I always love your avatar, that little spaceship. I love it. I think it's great. I think it's really great. Thank you so much. So I'm going to give $100 after the stream to Karen Reed's Defense Fund.
30 days. I do know that there was materials on that DVR, NVR back in July of 2024. And I know that from a report that was generated by the Commonwealth and given to the defense.
Actually, I can make
They should
that
know
donation
as
right
well.
now. Hang on.
That may be one reason why they wanted to come out. They came out on their own volition. I extended the courtesy as much as I could, made no promises. I was clear. I was very uncertain about what would be on there since I never looked at it. After I learned there was no information on the NVR, I took the initiative and went to the police department. I viewed the police department, the cameras. I spoke to personnel, and I spoke to the retired individual who then was responsible for providing video upon request. And when I spoke to him, he told me in conversation that he would routinely store a copy on a file he noted as a detective file or on his hard drive. That was news to me. I thought that was helpful, so I notified the defense about my conversation. I was not trying to lure them back to Camden or have them spend money. I was trying to, as I always do, be as transparent as I could and as helpful as I could. Now, what I simply should have done and could have done is I could have gone to that detective file and downloaded the video and given a copy to the defense. That's my obligation, no more. But I didn't. I extended the courtesy that if they wanted to come and look at that file before we opened it, so it could be beyond reproach, they were invited to do that. I wasn't encouraging or luring them. I was inviting them because they had already been part of the process. I thought it would be disingenuous not to let them participate. And what they told me is to wait. So now that information, whatever it is, I don't know because I haven't seen it. And I've asked the detective or the retired detective not to access it. It is sitting in that file, supposedly. So at this point,
it's sitting in that file, supposedly. It's a little scary.
Almost position that we are going to go and download that information to give a copy to the defense. The defense waited almost 3 years. The defense was very clear about my uncertainty would be on that tape. And now they stand before the court and they try to parlay this into some type of injustice for their cause. The case they cite, Commonwealth versus Frith, the district court was overruled in assessing costs because there was no egregious violation. This is not a Brady case. This is not a setup. This is the government providing information as the case progresses and evolves and changes and retools. So what we have now is information, supposedly, on a database that we are going to get and give to the defense. You should deny their motion. Nobody was misled in this case. They've taken a professional courtesy in an effort to help, and they've distorted it into some type of injustice. The Commonwealth's not going to be distracted from the cause in this case, which is a trial on April 1st. The court should not.
Real quick, just so I'm transparent here. I was like transparency. But there we go. Made the $100 donation. So we got you, Karen. Brian LTL Media. We had another $20. $20. Love it. Brian LTL Media sent me hashtag free Karen Reed and justice for Officer John O'Keefe. So 120 raised so far during this stream. Good stuff. Love it. All right, let's get back to hanky panky here.
Distracted from the cause in this case. If they have a separate motion about Rule 14 violations or motion dismissed for misconduct, that's a separate motion. That's not the motion before the court today. The motion before the court today is to attempt to recover costs for something they chose to do and that I accommodated. It should be rejected. Thank you.
Okay. Any quick response, Mr. Jackson?
Very briefly, with the court's permission.
Keep in mind, Bev's made her mind up. And I don't think it was this hearing, but I'm hoping we hear it. It could have been this hearing or the Alessi hearing, the one previous to this. But Bev is dead set April 1st, we got to keep the schedule. We got to get this trial going. I think it's this hearing, but I could be wrong. It could be the previous hearing. But I'm going to tell you right now, when that motion to dismiss comes through on the 11th, she's going to go, denied. She's already made her mind up.
By the way, it is a Brady case. There's no question that the data on those videos are Brady. They're exculpatory.
Excuse me.
That's where we start. So Mr. Brennan can say all day long, that's not a Brady case. Don't worry about it. Let's just sweep this under the carpet like we've done everything else. It's there's nothing to see here.
Yeah.
That's not true. It's a Brady case because the information that we have now received from that DVR, that NVR system, is exculpatory to Ms. Reed. That's why I cited
Brian Higgins part?
That's why I cited the Brian Higgins part. Correct. And I suspect there's a lot more on there as well. The inverted video part is also great, which we got in the middle of trial. Mr. Brennan says, basically, his argument is, deny the motion because they took a courtesy. I'm trying to be courteous. And he's a gentleman. This is not personal to Mr. Brennan. He seems to, the tone of his responses was, well, this is personal between Mr. Jackson and Mr. Brennan. It's not personal at all. This is about the defense and the Commonwealth. It's about Ms. Reed and the Commonwealth. But let's not conflate a courtesy with an obligation. The Commonwealth has an obligation. I don't care that Mr. Brennan wasn't on the case previously for the last 2.5, 3 years. It doesn't matter to me. This is not personal to him. I appreciate the fact that when he came on.
It'd be great if Jackson paused there and pointed to Lally and went, no, it was that lackey right there. Oh, man, we're never going to hear that guy ever again. He's just going to sit there and make the coffee for everybody at the table. Ultimately failed. He is the whipping boy now, and deservingly so. Deservingly so. All right, let's go here.
Onto the case. He immediately found in August, he found a video that had never been turned over.
Scary.
I can't fault him for that. He turned it over when he
Thanks for
found
the
it.
$10 on Cash App.
What I
Appreciate
can
that.
fault is the Commonwealth. Mr. Brennan was brought onto this case not to represent Mr. Brennan, but to represent the Commonwealth. And all the foibles, all the warts and blemishes that preceded him, unfortunately, are now his responsibility as lead counsel for the Commonwealth. He indicates that when he found out that we wanted to come look at the DVR, and we had absolutely no right to look at that DVR, this was just a courtesy, et cetera. Well, that might be true if we hadn't made the request, because we had been getting piecemeal videos from a DVR system that it supposedly was overwritten.
So the oral request by phone call you're talking about?
The latest one, right. So my request to come out and have an expert come out and see it. That's not just a courtesy. That's just good lawyering on his part and mine.
I was going to answer this really quick. Tammy says, surprised Lally still has a job. It's optics. It's all optics. It wouldn't look good if they fired him. It wouldn't look good if they fired him. So what do? Stick him at the table, bury him, get the new guy in here. And he's never going to ever speak or do anything in this case ever again. He's going to sit at that table. It's optics. That's all it is. It's optics for the Commonwealth. It's optics to put it out there for the public. Hey, look, Lally's still on it. He's helping out. But we're going to have Hank step up this time and be lead counsel. It's all optics. Super optics. Because it would look bad if they fired him. It would look bad if they fired him. So you got to keep him there. So what do? Bury him at the table. Make coffee. Go make copies upstairs on the copy machine. That's all it is. All right, let's keep going here.
You want to keep your hands clean. Let's do it the transparent way. Have everybody come, bring their experts, whoever they might be,
Exactly.
and let's download this stuff together. So there's no funny business, and everybody can wipe their hands and say, I didn't have anything to do with it except downloading the material, and whatever that material is, it is. That's just good lawyering. It's not a courtesy. He was doing that to protect his own and the Commonwealth's interests, and it was quite smart until he realized, because he didn't have any way of knowing it any more than I did, that there was no footage. It had been overwritten. perhaps, certainly the defense was deceived. Perhaps Mr. Brennan was deceived as well. He indicates that he contacted Chief Rafferty, and she said, with no hesitation, yeah, bring him on out here. I wonder if that lack of hesitation had anything to do with the fact that the chief knew that there was no data on the DVR.
Scary.
Come look all you want to. The bucket's empty. I have no idea about this iCloud account or who owns the iCloud account, why this data on January 29th was moved from the DVR to the iCloud account. Mr. Brennan did say, do you want to have your expert come back out and watch as we download the iCloud account? And I said, let's defer that because this is literally, these are the contours of motion that's going to be before the court. And I still want to defer it because what I didn't want to do is pay another $12,000 or $15,000 for a second bite at this apple just to find out that iCloud account is somehow compromised as well.
We got about $140 that we've made so far via the stream for Karen Reed's defense fund. I appreciate the people that have dipped in there and have donated. You know, I'll look at this. Maybe we could put a little challenge out there. We got about 460 people in here. All right. 460 people. Let's say $5. If we have every single person in this room right now donate at least $5 to the Karen Reed Defense Fund, I'm going to drop the link here in the chat. All I need you to do, please, people, please, my subscribers, my members, my moderators, if you can, click on that link and just donate $5. 460 people, that would be $2,300 we would raise here today on this stream. And if you do donate, please just put something in there like LTL Media, just so I can track them and we can do kind of a rough total at the end. If we could get to half of that, if we get to $1,000 today, that would be phenomenal. That would be phenomenal. So I'm going to drop the link there. Just even $5, less than a Starbucks cup of coffee, less than a gallon of milk, $5. That's all we need you to do. And put LTL Media in there in your comment so we can kind of do a rough total at the end. All right, let's keep going here.
You have someone record it? Can you have somebody that it won't cost you $12,000 if you want to come out and just have someone record it as it's being done?
Sure, I didn't mean to interrupt the court. Yes, I can certainly make accommodations.
I've been him. Thank you for becoming a new member.
That may be an option that we exercise. I may be
Excuse me
about that because I still want to have some transparency on that process. But what I don't want is to throw good money after bad at this issue when she's already spent $12,000, $12,200 and something dollars for absolutely nothing. This is not a matter of courtesy. This is a matter of obligation. This was a matter of Brady. It's no different. And by the way,
it's a matter of Brady.
The case that Mr. Brennan cites, he indicated that I cited that case. I didn't cite that case. Justice Gaziano cited that case in his opinion in the committee case.
Oh.
And the ultimate opinion of that court was when there is a discovery violation.
Thank you.
When there is a Brady violation, and there is no question that that's what's before this court. Blatant discovery and Brady violations. The Commonwealth doesn't, the court may remember, by the way, on the witness stand when these videos were coming in piecemeal, especially the inverted video, 2 or 3 witnesses
Thank you, Tom.
all went like this. I wasn't the one told it. I wasn't the one that downloaded it.
Thank you, Scott.
I wasn't the one that downloaded. I don't know where it came from. It just ended up on my desk on a flash drive. I don't know where it came from. Everybody was pointing fingers at everybody else. Nobody could establish a single chain of custody.
Awesome. I love you guys and ladies. Thank you.
So Chief Rafferty's statement, yeah, come on out. No hesitation whatsoever. They can come look at it. I suspect it's because she knew it wasn't there. This was we were led in a circular runaround, and it was ultimately at her cost, and that's what's
so. Didn't the two of you, when you talk about good lawyering, didn't both of you agree that it was highly unlikely it would still be there, or are you saying that part's not true? Mr. Brennan told me that.
I said, I'm concerned if we don't get out there fast. I don't know what the override protocol might be. So yes, I was concerned, but
like a month, Peggy.
Well, that's no legal moment. What I thought and what Mr. Brennan and I discussed 3 years after the fact, when the Commonwealth has a self-executing obligation to provide that information to us because it's Brady. They also had an obligation pursuant to Mr. Yannetti's demand, not request, but demand to maintain that information.
So where is that demand? Is that in the file? Where is that demand?
February 2nd. I don't know what the docket number is. It was filed.
She's acting like she doesn't know where it is. Impossible. She's not, oh, where is it? Believe me, you've seen it. You've seen it. What was I going to say here? I totally just lost my thought process. All right, let's go.
February 2nd, after arraignment.
Here?
Wherever
Rebecca, thank you so much for the 5 on Cash
It
App.
was in the Stoughton District Court.
Okay.
I love all the
But it's part of the
donations.
case file.
So awesome. $5.
And it stays with the Commonwealth, and that obligation
that
stays with the
defense
Commonwealth.
link
But I would propose to the
and
court,
donate
that
$5.
even if the court's concern is, well, when was that filed, and did Mr. Brennan
No,
actually?
I haven't seen it. I know it's not part of our file, and you're talking about it as if it were here.
Your Honor, I can't say with certainty, but I believe that it may have been submitted as an exhibit to a previous motion, probably early on in this case.
Okay, I
so-
just wanted our record to be clear.
Of
You're
course.
talking about Mr. Yannetti filed this. You did not file it in this court
I may have filed it as
as an
exhibit.
attachment, but it was
but
never
not-
any,
Right. There was, I don't mean to cut off the
no,
court,
no.
Judge.
It was never brought before me or a judge who had this case before me to be heard.
So there was early on, and so many motions have been filed in this
Right.
case, but early on, I did bring a motion, I believe before Your Honor, asking that all of the Stoughton District Court motions that I had filed at arraignment and thereafter be ratified by this court.
Okay.
That is in our record.
So I need you to find that
Happy to do it.
and tell us when it was filed, the act. I need to see
By
that.
the end of the day today, you will have whatever submissions we provided, and if it's not part of an exhibit, you will have that motion.
All right. Go ahead,
Just
Mr. Judge.
to answer that one question that I can't answer because I've seen the filing. It was filed February 2nd, 2022.
Shelly, thank you for the 25 on Cash App. Appreciate that. And if you want to donate to Karen Reed's Defense Fund, I'm going to drop the link there in the chat. And there is right now just about 500 people in here. It would be awesome if you all could click on that link and just donate $5. And I'll post it there again too. Click on that link, donate $5 to Karen Reed's Defense Fund, and just put in your comment, LTL Media, something of that sort, so we can kind of add all these up, get a rough estimate at the end. I know a lot of people have been donating, and I appreciate that. And we could, with 500 people, we could raise a lot of money. 500 people in here, we got $5 donation, it'd be $2,500. $2,500 like that. Super. Less than a cup of coffee. Less than a cup of coffee. All right, let's go.
Court stand. My point is, even if that weren't the case, and it is the case, the obligation is self-executing. That's what Justice Gaziano was talking about when he talks about in the committee case, the self-executing duty that a prosecution has or a prosecutor has to maintain and preserve exculpatory information and provide that information to the defense. They didn't do that. And they led us to believe every single sign and signal, irrespective of what Mr. Brennan did or didn't actually personally know. The Commonwealth's conduct in this case, from the beginning of the investigation to now, suggested that that information existed, the DVR existed, the video footage on the DVR existed, and we were going out there to download. We shouldn't have had to jump through this hoop and go on this wild goose chase at Ms. Reed's expense.
Seriously.
It is not, I think we can all in this courtroom agree, none of this is our fault. We didn't do any of this. It's all on the Commonwealth's shoulders. It's all their responsibility.
I would
We
hope
should
so,
have to
Ken.
pay for what happened when we went out there for absolutely no good reason. And I'll send that.
All right, Mr. Brennan, I have just a couple of questions.
Yeah.
So you don't know for certain whether this information was in fact downloaded onto the hard drive, but you suspect it is based on your conversation with the named gentleman in your affidavit?
So there's two different systems. One's called the DVR NVR. That's the actual system that keeps all the footage that's recorded.
That
That has been
that
served.
commonly is overridden every
Yes.
30 days,
That
like
has been overwritten.
statewide police departments.
Yes, Your Honor. And
Okay.
that has been overwritten,
Okay,
and there is no information on that.
okay.
When I spoke to the retired sergeant detective who had downloaded video, he said as a habit, he would routinely, when he would make a video copy from the DVR, he would place it in a separate file. I can't say that it's exhaustive. I can't say that it captures all of the video. It's when he would make a copy. And it seems in this case, there were select copies made. It doesn't seem that there was ever a time when somebody just copied the entire event. Now, the issue of whether there was a request for it, the obligation of the Commonwealth, I think is a separate issue. What exists on his hard drive in the detective file, I don't know. But what he has told me is he would routinely make copies of what he would provide to the court and the Commonwealth, or the Commonwealth and defense, and he would put on that separate file. I don't expect, and I'm only guessing, that it's going to be an exhaustive copy of the entire night of January 29th, 2022. I don't expect that. I expect it will be a copy of whatever it is that he has provided in this case. And so I think before
Scary.
it just lingers there forever, it should be copied and it should be provided to the defense.
All right, so I do want you and Mr. Jackson to talk about whether within the next week you do have somebody video it, or at your expense you send somebody out at it, but let's get moving with that. I know you said you'd make download a copy and send it. Are you satisfied with that, Mr. Jackson, or do you want to have someone there while that occurs?
I at least want to noodle on that for a second, but I'll talk to Mr. Brennan about it.
All right, I'd like it done within the week. The person has to be there within next week, or the Commonwealth will download it. We've got to get this case moving, and you want it, so it's got to be provided.
There it is. That is what I was looking for. I knew it was going to come up. We got to get this case moving. She's already made her mind up that this is going to go to trial. She's already made her mind up. So that motion to dismiss, the lengthy motion to dismiss that Karen's defense team is going to write and submit on the 11th, she's going to thumb through that. Denied. We've got to get this case moving. She doesn't care. And if this was an honorable, in my opinion, moral compass judge, this case would have been dismissed on this day for Brady violations. Nope. We got to get this case moving. All right, let's go.
The stall isn't my fault. Yes, we want it. That's why we asked for it in the first
Yeah,
place.
so let's try and work it out before you leave here today, okay?
Sure.
Darn it, I'm happy to defer at the defendant's request. I'm prepared to do it now. If they want me to wait, if they want to have somebody there, I'm receptive, but we're ready to do it now.
All right, so I'm telling you to please wait, work it out, but no later than next week.
I understand.
All right, thank you. Did you want to?
Look at the body
Did you wanna
language.
be
of the
heard
defense
further
team.
on
Yeah.
your response?
Your Honor, although I've come to this
Jackson's
case late, I am the Commonwealth, and I assume all responsibilities of the government's case in the history of it. This motion is not about a Rule 14 complaint or a violation. If the defense has a motion to sanction
Excuse
or
me.
to dismiss, whatever the remedy is, because they think they've been agreed, that would be a different motion. This motion
Exactly.
is they're trying to get
Katie.
the court or asking the court to impose costs because they had their expert come out at their request, and they were very clear about the risk associated with that. This motion should be denied. If there's a separate motion, we'll deal with that when it's filed. If I had known that the defense was going to argue something entirely different, and that is the failure to preserve, I would have made a copy of all Mr. Yannetti's.
Real quick, just want to acknowledge you, Shelly and Patrick. Thank you so much for the cash apps. Appreciate that.
Motions and requests, and I would have provided them as an exhibit. But I did not do that because that was not the scope of
Joe, thank you for the
This motion
cash
should be
app
denied.
or Venmo. Thank you.
Very much. Taking this under advisement.
Sure
And
she
Do
is.
not wait for a decision from me on this about whether or not you send somebody out to
We
get
won't.
that video.
Gotta get
We'll get
case
started on
moving.
that immediately.
All right.
Gotta get the case moving.
All right. So
Gotta get this trial moving.
Let's move on to the Commonwealth's motion for clarification regarding the search warrant. Or the contents of the defendant's phone, more accurately. Please.
In reviewing the discovery in this case, I learned that there was a search warrant for Miss Reed's phone. That search warrant entitled the Commonwealth to search for data that's outlined in what's known as addendum or attaches addendum A. Learning the history of this case, I further learned that because there was an assertion of privileged communications, there was an agreement that the Attorney General's office would look through the data on the communications, and they would identify any attorney-client privilege information, extract it, and then provide the information back to the government and the defense. I am not sure of the accuracy, but I learned or read that the defense was given an entire data copy, forensic download of Ms. Reed's phone years ago. When I looked through the discovery, it surprised me that the Commonwealth did not receive the forensic data. It received a report. And when we reviewed the reports, it had references to navigation information and Google searches, but did not have any of the forensic download. And so clearly, the Commonwealth has a warrant, is entitled not only to the PDF extraction, they're entitled to the full force of that proof, which is the data. I spoke to my experts, and they advised that they believed that the data would have more information than simply a PDF. And so when I learned this, I wanted to both scrupulously protect the defendant's rights, but I also wanted the data for our review. And so I limited my request for the data to navigation information in the Google searches. Although I do not believe it was required pursuant to the communication protocol, I asked the Attorney General's office to engage in that protocol anyways, just out of abundance of caution and respect to the defense. I contacted the defense. The defense offered their objection. I think it has no legal merit whatsoever. They don't have standing at this point, but I noted their objection. I believe, without certainty, that the Attorney General's office has gone through that review to make sure there are no communications. However, they expressed some reluctance to provide the information because of the existence of the communication protocol, and they did not believe there was enough clarity that there was a distinction between navigation information. I do not see that navigation information, Google information, or the other data that I want is covered by the protocol. I believe that protocol has at least partially already been followed anyways. Time is of the essence. This case is on for April 1st. There is what I believe to be relevant material, important information, including Google information and navigation information that we are entitled to. I don't want delay. So I filed this notice so that the court could give direction, either assuring the Attorney General's office that they could provide the information, or if there is going to be a protocol, which I discourage, that it's expedited. If there is something the defense wants to look at prior to me receiving it, it should be on a very, very narrow time frame. I don't think they have a right or entitlement to review anything I get. I think the Commonwealth is entitled pursuant to the search warrant. If they have a remedy, it's after we've already reviewed it, not before. And so I'm doing this to facilitate things because I'm mindful of the April 1st file, and we will pursue this information and use it if relevant.
Okay. Is there an opposition? I don't have anything in writing.
Your Honor, not really. The only thing that we expressed.
Real quick, I just want to pause this before we get to Jackson's retort. I'm going to drop a link, and that's the Karen Reed Defense Fund link. If you haven't and you have the means to do, I really would appreciate that. Click on this link. Go to the Karen Reed Defense Fund website. Just do a $5 donation, and in your comments, put something in there about LTL or LTL Media. I want to total all this up at the end of the stream. It'd be great if we could get to like 500, $1,000 by the end of the stream to raise for Karen Reed's Defense Fund. But use that link, click on it. If you haven't and you can, just a $5 donation would go a long way. A long way. We have over 500 people in here right now. That'd be $2,500. We could do that. All right. Let's keep going here. Mr. Jackson.
Mr. Brennan was, and maybe I misunderstood his first, it was a communication we had on the phone. I thought
Excuse me.
that he was seeking something far broader than the search warrant. It sounds like he's staying within the parameters.
It sounds squarely within the
Right.
search warrant.
So that doesn't bother me. I want to make sure that whatever information he gets is squarely, as the court just said, squarely within those parameters. On January 28th at 9:30 p.m. until January 29th at 5:30 p.m. And otherwise,
Denise, thank you for
I
the
don't
cash app.
disagree that-
$20 cash app. Appreciate that.
To the search warrant, we can get the raw. I'm calling it raw data, but I think we all know what we're talking about. Not the PDF, but the underlying data.
All right, it's squarely within the search warrant.
Right.
I do feel Mr. Brennan did not have to come to me or even you with it, but I do appreciate that you did so. So yes, so the AG's office knows that you are entitled to that information. You may have it immediately.
Thank you.
Okay. All right. So the motion regarding, just want to get Commonwealth's motion for reciprocal discovery pertaining to employees of ARCA. And then if you go one step further than that, are we going one step further than that with the second motion today? Or do council want to come to sidebar? and
Awesome.
tell me
Thank
any
you.
Information you have? Or how do you want to do this?
Whatever the court's most comfortable with.
I'd
An open court or sidebar.
I'd prefer to find out what's going on over in federal court at sidebar first.
Yes, Your Honor.
All right. Obviously, we're going to speed up for the sidebar hearing. It was a lengthy one. All right, let's go. So how is everybody feeling about Karen Reed 2.0? Do you think that this trial is going to start on time, the April 1st deadline? If you think it is, put a Y in the chat. If you don't think it is, put an N in the chat. I'd love to see. Oh, might have to speed up a little bit here. It's even a travesty that this is even going to happen at all, but I'm just curious to see.
All right, so I will hear you, Mr. Brennan, on your motion for
I
reciprocal
agree.
discovery.
A lot of mixed emotions here.
Your Honor, we're expecting to file a certificate of compliance this morning. We've provided voluminous discovery to the defense, and it is now incumbent upon the defense to reciprocate pursuant to the rules. I filed a motion to reciprocate. Also, there is a specific motion regarding expert witnesses relative to so-called ARCA experts.
So-called ARCA
Those
experts.
requests are consistent with information that we routinely provide pursuant to Rule 14. And we are asking that the defense comply if they expect to call these witnesses at trial.
And you have specific requests for the discovery, right?
I do.
All right.
So-called ARCA
Mr.
experts.
Jackson,
Thank you, Your Honor. I appreciate the opportunity to be heard on that. I appreciate Mr. Higgins'
Excuse me.
indication that he intends to file the certificate of compliance today. We know what our obligations are under Rule 14, and we intend to comply.
okay. All right, so the motion is allowed. And Mr. Jackson, you had a scheduling concern?
I do. Concerning we received notice of discovery number 58 last night. I'm guessing it contains between a dozen, maybe 15 categories of new information that we're getting within that notice of discovery.
New
Substantial,
information.
including multiple experts, some individuals that we've never seen anything from. There, I believe that upon review and analysis, some or all of that will be relevant to our motion to dismiss, which I think is going to be pretty full-throated. The court indicated that it wanted us to file our motion to dismiss, I think, by the 11th, which is in 6 days from now. I don't think that's a reasonable possibility. We simply cannot get it done that quickly. I would ask the court, urge the court to allow us until sometime the beginning of March. We've got several dates on calendar. I don't have them committed to memory, but we'll be back at the beginning of March. That motion to dismiss, I think, if we have the time to do it and get it filed by the beginning of March, it's not going to take an enormous amount of court time. The time that's going to be taken is our preparation of the motion. But actually arguing it and ultimately the court
Thank you, Susie.
taking it under
Yeah, we try to
advisement
do
and
these.
deciding on it, I don't think it's going to be that burdensome. Although it's going to be a very, very full-throated motion.
All right, so you first raised the issue, I believe, in a footnote on one of your other motions that was filed, I don't know, January 21st or earlier.
Remember, this is a new trial. Remember? It's a new trial. But again, if there was some moral compass here and there was some ethics and just being a good, solid judge, this case would be dismissed right now. You know that. I know that. Everybody in this chat room knows that.
That this motion to dismiss is coming. You had a motion to dismiss it, the last trial, the same thing, forecast, and then it's coming, it's coming.
She doesn't care.
I need that motion in order to get it heard before then.
Yeah. So she just wants to thumb through it. Denied. Denied. You know that. She's already, her quote, we got to get this trial going. You heard it like 10 minutes ago. We got to get this trial going. It's unreal.
Let me hear what the Commonwealth has to say. What's the extent of the information that you provided today or yesterday?
In the most recent discovery,
Yes.
it was voluminous.
Okay.
We provided a number of expert witnesses, entire files of expert witnesses. We've been providing discovery in an ongoing manner rather than wait until the end. When I've retained an expert, we've notified the defense. When we have reports, we've notified the defense and provided them almost immediately. But there is quite a bit of information that we put together regarding expert reports and data information, accident reconstruction, phone investigations.
Exactly, Michael.
So we sent it by link because it was extraordinarily large.
Okay. Does the defense anticipate evidentiary motions in this case? Got time that maybe I can flip these. Do you anticipate evidentiary motions?
Can I just?
Yannetti jumping up really quick.
I don't anticipate evidentiary motions from our end. Obviously, if that changes, I'll let the court and counsel know immediately, but I don't think so.
How about the Commonwealth?
There are none expected.
Mr. Jackson, I'll give you until February 20th to file that motion to dismiss.
So they're going to get an extension.
And we'll hear it if there are no evidentiary.
Additional 10 days. Excuse me.
Commonwealth, I'd like you to comply with your response if you could by the 27th, 28th.
Yes.
Oh, wait, this is March. I'm sorry. No,
Yes.
February 20th.
And then some.
Yes, if you could have it by the 27th, please. And then we will have a hearing on it on March 4th. If there are any evidentiary motions, they must be filed by February 11th.
Whoops. My fireplace showed there. Sorry about that. There we go.
And I want you to talk about whether we have a voir dire of the defendant's proposed witnesses, because we'll have to do both at the same time.
Your Honor,
Right.
is it possible? I'm just looking at the calendar for the first time as the court's going through its calendar. Is it possible that I could urge the court to allow us the 24th to file a motion to dismiss? That gives us a weekend. That is incredibly meaningful for us.
I need my
I don't
weekends
wanna
too.
Hamstring the Commonwealth if they need until the 3rd to give them a weekend.
No,
Possible?
but also I need weekends.
Right.
So it's not possible. So I'm giving you from February 11th to February 20th.
Maza
I'll give
Media.
you to the
What's up,
21st.
buddy?
Okay, 21st.
How are you?
Commonwealth, I'll give you to the 28th. Okay.
I
Thank
need
you.
my weekends.
All right.
So Judge, are we taking off 218?
We're going to take 2/8. Let's keep it on now. If you work out if you believe that it would be helpful after talking to do of what.
Mazi, are you streaming today? Don't you have something set up like a pre-show? Are you doing a pre-show today? Because I want to just make sure I direct everybody over to your stream. I didn't see it set up, but I had heard something. You're doing a stream. If you want help, let me know. I'll come hang out on the panel. I don't mind. At noon for Super Bowl. Sweet. You're doing something at noon. All right. All right. We're going to try to finish up here, get going. I'm going to get some food. And
voir dire of those witnesses. We've got the 18th free.
so he will be streaming at noon. I'll be doing a lot of fundraising.
February. You were supposed to be here anyway on your motion to dismiss.
Okay, I'll discuss it with Mr. Brennan.
All right. Thank you all.
Yeah, I noticed
May
that
I?
the other day
Yes,
too.
I'm sorry.
Aaron's got a
A
laptop.
few things, housekeeping matters. One, I'd like to set a date for reciprocal discovery. There has been no
Yes.
date sent. I'd like to.
All right, so you are filing your notice of compliance today. Do you have it now to file?
I do. Can I just show
Okay.
it to the defense?
Sure.
All right, they're just going to talk about scheduling. I think we're through the majority of the hearing here. Not too much more. It's actually going to end here in a second anyway. Okay, good stuff. Let's check in and see what we raised during this. Can someone do this? Maybe one of my moderators take out their trusty calculator and I'll call off some donations and we can get a total of what we did here at the end of the stream. Or even just someone in the chat. Just give me a yes if they can help me out. I'm going to call out these donations. We'll wait. And then we're going to head off. I'm going to get some food and I don't know, hang out. Awesome. Someone help me out here. All right, let's share the screen. Let's do a refresh here. And hopefully we got some LTL media stuff in there. All right, I'll call these out. Mary says she's going to try. Yeah, cool, Maz. I'll join. I was going to run up the street and grab a sandwich really quick, but I'll definitely jump on, man, and hang out with you. I'm ready to go today. I want to help out the streams. Great. All right, let's take a look. All right, add $5. Another $5. Another $5. Another $5. Another $5. We have $10. We have another $5. And I'm going to say, Patrick, I know Patrick was in the chat. That's another $5 plus 10 plus 5 plus 20 plus 5 plus 10 plus 10 plus 20. There's the big dono for my channel, $100 plus 20. And I think that's where it stopped because I remember seeing this $100 donation before we started. Can someone give me a total? That would be fantastic. Hopefully we got it. See how much we raised. I'm going to say it's probably close to $300. $245. Yeah. All right. $245 in the piggy bank for Karen. Good stuff. Head math. I love it. $245. Hey, we'll take it. It's $245 that was not in that defense fund, but it is there now. I want to thank, real quick. I just want to play this really quick before we head out. I saw this clip, another little extended clip here.
Boston 25 News. It's the biggest
Good to see you.
interview of the year.
It is unusual for someone who's accused of murder to do this interview or others.
I have nothing to hide.
Karen Reed sits down with your local station.
What is the one thing in this case that you believe proves your innocence?
Karen Reed one-on-one with Ted Daniel. Super Bowl Sunday, right after the floor on Boston 25.
So The Floor is a game show with Rob Lowe. I'm probably going to say this interview is probably going to be about, probably 11 o'clock tonight, maybe even midnight, because that floor show goes about an hour. I'm going to try to dig in a little bit more and see what I can come up with. And if I can get a time down, I'll try to stream it live here and hang out. Maybe we can get some of the other creators over here to hang out. But anyway, thank you all so much for this Sunday morning wake-up show. It was phenomenal. I'm going to go join Mazza here in a little bit and hang out on his stream. I'm going to go grab a sandwich really quick, and that's it. So I appreciate all the new subscribers that have come into the channel lately. We're really killing it over here. All the new members, all the people that have donated, and all the fantastic people today that donated to the Karen Reed Defense Fund. I appreciate all of you, and I know Karen does as well. I'm going to head out. I'm going to go grab some food, and then I'm going to bounce over to Mazza Media Stream at noon. Please come over there and join us, and we're going to hang out and raise some money for Karen. So I'm really excited to go do that. And Peggy, thank you so much for the big super chat today of $300. I took 100 of that and donated it right to Karen Reed's Defense Fund. So I love all of you. Thank you for helping me out here on this channel and continue to grow it. If you haven't gone back, there's 2 super streams that you need to go check out. Check out both my streams with attorney Nan Gallagher. They were wonderful, and she's fantastic, and I cannot wait to have her back here on the channel. That's about it. If you haven't seen already, I worked in the room yesterday. We got the new chair, the new setup for when people come in and hang out. I'm very happy about this, and I think it's looking great in here. It's comfortable. And I think we're going to have some really great interviews in here as well. All right, everybody, I'm going to head out. Thank you all so much for being part of the LTL family. I love all of you, and I will see you in about an hour on Mazza Media Show. Bye.